Good morning, Your Honors.
Good morning.
Annabelle Majeski on behalf of Mr. McElreath, and if I may, I'd like to reserve 5 minutes for rebuttal.
Very good.
In this case, the parties agreed to the facts. There was an automobile accident where Mr. McElreath his car was damaged and it was injured. We also agreed that there was a settlement which settled the bodily injury and the property claims. However, the settlement, Ms. Gonzalez says she is not admitting liability, and Mr. McElreath stated that his claim for punitive damages is not included in the settlement. So we also agree that a claim for punitive damages has to depend on an underlying claim. You can't just file a complaint for punitive damages.
So the filing of this lawsuit in the manner that it was filed, knowing what had been settled, seems to be an effort to get around that rule that you said basically applies, that you cannot file a separate punitive damages claim.
Except for the fact that the argument below was that, and the trial court granted summary judgment based on the fact that since Mr. McElreath has no damages because his damages were settled, which technically doesn't mean he doesn't have any damages. It just means that the amount of his damages is already determined. That he has no underlying claim, and our argument is that.
But do you agree that he had no underlying claim left other than now a punitive damages claim?
Well, he still has a claim to determine the liability. Because since she did not admit liability, and the punitive damages claim depends on liability, not on whether he has actual damages.
But you agree that there's no separate cause of action for damages for liability other than damages for punitive damages, to the extent there'd be liability for punitive damages?
At the moment, no, because his other damages, his monetary damages, his collateral, his property damages, and his bodily injury damages, he has received an amount for those damages. But he still can bring...
The settlement says that it is in full settlement and satisfaction of and sole consideration for the final release and discharge of all actions, claims, and demands whatsoever that now exist or may hereafter accrue relating to or resulting from bodily injury. And then later it does say that it doesn't apply to any claims for exemplary or punitive damages. So it seems that the lawsuit that was filed, this is a strong word and maybe I shouldn't use it, but to a degree the lawsuit that was filed was a sham in regards to any liability other than punitive damages. I mean, that seems to be what the trial court ultimately concluded. You don't have a claim except for punitive damages, and you can't bring that claim separate from another existing claim.
Well, and I don't think, yes, we all agreed she couldn't have just filed a claim and say, I'm suing for punitive damages, because the reason it has to be...
But isn't that essentially what she did?
No. What she's saying is you have to first determine liability, because actually, say there hadn't been no settlement. Well, she wouldn't have received those damages either without proving liability. And so what we're saying is she has to bring the claim for liability in order to attach the claim for punitive damages. That's correct.
What in this lawsuit, in these circumstances, what would be the point of getting an adjudication of liability apart from the punitive damages claim?
The adjudication for liability would then allow a jury to determine the punitive damages part.
And my question was, apart from punitive damages,
okay,
what would be the point, what would be why do this endeavor of impaneling a jury and having a jury trial solely on liability alone?
Besides the punitive damages?
Yes, ma'am.
None. I admit, there's none.
Okay.
So what does a release protect the party from? The defendant from? This very thing, right? Being hauled into court for any cause of action whatsoever?
And
now
I don't-
existence or hereafter?
I don't know why that language was in there then about the punitive damages claim. Apparently, it was still discussed, and I think both sides knew that this was going to be pursued, especially in light of the fact that this was a drunk driving case, and punitive damages are allowed to be, you're allowed to claim for punitive damages for sure, in the circumstances where a drunk driver is involved.
So there's two provisions here. One that there's no inference required, which is that the release is to all claims now existing or hereafter arising. And then there is another provision of this agreement between the parties which requires an inference that you were suggesting, which is that the parties may have contemplated future proceedings.
Well,
Contract interpretation, can this inference requiring provision vitiate the provision that is explicit?
It's explicitly, well, one is in general, whatever other claims may or may not arise, but then you have specific language that says the punitive damages claim is not included in this settlement, and I think the specific language supersedes the general language of all and any and all future claims and liabilities. I think that probably, since the settlement was addressing the bodily injury and the property damage claims, that it would seem to be interpreted as any future claims that pertain to those two damage items, instead of, especially when you have excluded a third part of the claim, which was punitive damages.
Did your client seek relief from the settlement on any theory of mistake, fraud, misconduct, just any theory whatsoever?
No, I think
Because it seems to me that, at least arguably, this was either smart lawyering on the defense side and potentially malpractice on the plaintiff side to have worded this way, or maybe mistake, maybe there was some misunderstanding of the law. But it seems that under the law, the trial court concluded this is nothing more than a punitive damages lawsuit now. And so I'm not certain how we can get around that body of law, other than if we thought that there was a specific waiver by the defense to not challenge the bringing of a punitive damages claim. And obviously this settlement agreement doesn't say that. It just says this doesn't settle it. It doesn't say we're waiving anything. You know, you can have a waiver of statute of limitations. Maybe you could have a waiver that you're not going to challenge jurisdiction to consider a punitive damages claim. But I don't think we can read the settlement agreement that way.
But we also can't assume that the judge thought, well, this is, what the judge said specifically, his words were, since you've already settled, you have no damages because they've already been settled, and therefore you have no claim. And what we're arguing, and what the only thing that was argued below, is just because you have no longer have compensatory damages doesn't mean that you have no claim, because you still have to prove liabilities. You still have a claim for liability, and they did not concede liability.
Regardless of how the trial court characterized it, there's an argument on appeal of being made that you have no claim, period, because it was released.
Yes, but then I think at the rehearing, the judge said that it was interesting. It was a question of law. He wasn't sure what the answer was, because neither side could produce case law to support their argument. But he granted the summary judgment again still, because he said you have no compensatory damages, and therefore you have no underlying claim. And what we're saying is, just because you don't have compensatory damages doesn't mean you still don't have a claim to prove liability in order to then amend to add punitive damages. That's what we're asking this court.
So to follow that train of thought, then it seems like your position is we can file suit in count one for a determination of liability, but no damages that flow for compensatory damages. So what would the wherefore clause be asking for? A declaratory judgment that there's liability?
Yes. Because we have to, because this lawsuit is to establish liability.
And is there any, I think this was answered in the trial court, that there's no case law that would support a lawsuit simply for a declaration of liability in this kind of case, in a PI case like this, is there?
No, that's the whole issue. That's why the trial court just said, he sort of said, well, you know, this is an appellate issue, appellate court decision to be made as to whether this can be done. Because we do have, especially from this court, there's the first case that I would say is pertinent is this court's case in Nails v. State Farm, where in that case it was also an automobile accident, and the plaintiff did not meet the no-fault threshold, so therefore technically they had no compensatory damages. And this court said, I'll read it to you. The thrust of Cronin's argument is that an award of punitive damages must be supported by an underlying award of compensatory damages, which is the same argument that was made here. And therefore, if a plaintiff is not entitled to compensatory damages, in that case because of his failure to meet the no-fault threshold, in our case because they've settled the compensatory damages, he cannot recover punitive damages. And then this court said, we think our Supreme Court disposed of this argument in Lassiter v. International Union. In that case, the court held that the establishment of a liability for breach of duty will support an otherwise valid punitive damages award, even in the absence of financial loss for which compensatory damages would be appropriate. Amplifying that statement, the court said that a punitive damages award need only bear some relationship to the fact of the injury or invasion of legal right and the cause thereof. And then again in Alt v. Lohr, the Supreme Court agreed with this court's decision in Nails and said, we find that we should adopt the principles set forth in our dicta in Lassiter. We believe an express finding of a breach of duty should be the critical factor in an award of punitive damages. Accordingly, we hold that a finding of liability alone will support an award of punitive damages, even in the absence of financial loss for which compensatory damages would be appropriate. We reject Alt's contention that at least nominal damages must first be awarded. And that's the basis of our appeal, is the trial court based his grant of summary judgment on the fact that Mr. McElreath had no compensatory damages. And we're saying he didn't need them.
The context of those cases involved a claim for compensatory damages, but there was a determination that there was no actual damage incurred, right? It was not a separate lawsuit simply to determine liability plus punitive damages. No, it was a normal lawsuit where then, they were seeking damages, but then they were not awarded the damages for one reason or another. And in this case, we would seek, that's why the lawsuit sought in this case, was a regular liability seeking compensatory damages, and then they moved for summary judgment. First, because they said that we've already had a settlement on compensatory damages. So that meant there was no compensatory damages, and that's what the trial court focused on. The fact that there were no compensatory damages. And I don't know why we can't equate it to these cases in the fact that she did ask, Mr. McElreath was asking for damages, but the damages have already been determined, so therefore he has no damages. But we can still go ahead and find whether there was a liability or not, and so that we can proceed with the lawsuit and amend to add a claim for punitive damages.
I think the reason is because the body of law says that punitive damages claims aren't standalone claims. I mean, your client has no claim for compensatory damages at the time that it filed the lawsuit.
No.
Right.
But
So existentially, what they're bringing is a claim for punitive damages, right?
yes, that they would be entitled to, if they had not settled and they had just gone ahead and were asking for compensatory damages, they could have easily added the claim for punitive damages and probably been
I
awarded
think the
something.
real question here is can you contractually put yourself outside that body of law? And I don't know that either of y'all have developed that discrete argument in this appeal.
No, that's something new that we didn't, because we've focused on the fact that whether...
I know, you want to analogize it to the cases where there's an actual trial, where there actually was a viable claim, it was undetermined whether or not there's compensatory damages, jury determined no compensatory damages, court says, but you can still get punitive damages.
Yes.
You want to liken it to that. Okay, that's an argument. The point that what seems you're really trying to argue here, though, is, hey, this release says we're not settling punitive damages. We are settling compensatory. We now want to bring this claim in order to adjudicate the carve-out of the release, and we think that contractually we ought to be able to get around this body of law that says you can't just bring a punitive damages claim as a standalone.
And, well, but then the other factor is she is, in the complaint that she did file, she is asking for damages.
Which she can't get. I mean, she can't get compensatory damages.
No, but that's what we're saying. But she can still file and say that, and then amend.
How can you file a complaint that you know in good faith you cannot get the relief you are requesting? How can a lawyer even file that?
Because that is the only vehicle for her to get, for Mr. McElreath to get the punitive damages that he's most likely entitled to. I think that's why they reserved it.
That sounds more like an excuse than an actual argument of advocacy or justification. Look, I really want to get these punitive damages. I get it. I get that. How can you make in order to get that, I've got a claim that I can get compensatory damages. I can't in good faith make that claim. You can't elude the central question about how you make a good faith argument to get compensatory damages by the excuse that, well, I really want to get the punitive damages. It's kind of like the kid that lies in order to get into the cookie jar, right? I mean, it doesn't make the lie any better.
And counsel, you can answer the question, but I've let you go over a little bit because we have asked you a lot of questions.
Okay.
But you'll start eating into your rebuttal time at this point.
All right. Because I think I've made my point, and so there probably isn't that much for rebuttal. To answer your question, I don't know what the strategy was. I don't know why perhaps we would not have settled at all if we were interested in the punitive damages. I had no control over that, and I think that in good faith, they thought, well, okay, everybody knows we're seeking punitive damages, and we know that the case law is on our side. If the drunk driver is involved, that supports a punitive damages claim. Why it went procedurally the way it did, I cannot answer your question, Your Honor.
Okay.
Thank you, counsel.
May it please the court. My name is Deanne McLemore with the firm of Banker Lopez, and today I represent the appellee, Ms. Anna Gonzalez, in this matter. We're asking this court to affirm the correct decision made by the trial judge here that since Mr. McElreath settled pre-suit with my client's liability carrier, his entire underlying claim, he had no valid or existing cause of action for which to file suit or to seek any damages, punitive or otherwise.
So how do we interpret the paragraph in the release that says this release does not apply to claims for damage to property or any claims for exemplary or punitive damages?
Yes, Your Honor. So this release by the plaintiff that was done pre-suit with my client's liability carrier with a claims adjuster, the first paragraph settles all of the causes of action that could be brought from this auto accident. Plaintiffs carve out this exception to potential...
Well, the plaintiffs didn't carve it out. The parties to the contract carved it out.
Yes, my client's liability carrier pre-suit and the plaintiff's counsel. and it appears to be a carve-out of potential punitive damages. But just as Judge Lucas was talking about earlier, this is ineffective and invalid because you cannot circumvent well-established Florida law in doing so. Just as parties can't stipulate to jurisdiction where none exists.
But this isn't subject matter
No.
jurisdiction. And parties can waive all sorts of legal protections. You can contractually waive your constitutional right to a jury trial, right? So what about the issue that doesn't seem to be developed here that, hey, could you contractually get your way around this body of law that says thou shalt not file a punitive damage claim on its own?
Your Honor, I don't think that you can carve out this exception when the Florida Supreme Court and the statutory law is so clear that you cannot do this. You cannot bring a cause of action for punitive damages only.
Legal provision in a contract, they could not waive their right to defend on the basis that there was no underlying claim to support a punitive damages claim?
You were saying that my client, when she became represented after she was sued?
The part you said the carrier and the plaintiff entered into this agreement on behalf of
Yes.
on behalf of your client. Could a party not waive its right to defend based on the fact that there is no underlying claim to support a punitive damages claim?
I don't believe that a party can waive its right to, I guess, pre-suit if that was in the negotiations as part of that settlement.
The plaintiff pointed out that this specific controls over the general, so when you either give no effect to the carve-out for punitive damages in an agreement between two parties, or if you do give effect, which arguably you'd need to, it's a specific provision that controls over the general release. I guess I'm just trying to ask Judge Lucas's question in a different way. Cannot a party waive its right to defend against a future claim on a certain basis?
I think that if that was part of the negotiations, potentially they could negotiate in a waiver of that defense. I'm not sure. However, what I will say is what was before the trial court was not a contractual question. They have not asked below to interpret this contract in any other way. They haven't asked to rescind this contract. They haven't asked to get it set aside. So that wasn't the issue before the trial court. The issue was, this is the contract, this is the release, I should say, that came about this pre-suit settlement, and they're trying to seek a lawsuit for punitive damages. And the trial court, with his very narrow question before him, can you bring a lawsuit for punitive damages only, said no. And that is a correct that is a correct decision under Florida law, as the Supreme Court has said it. And that is actually what he found in his final order. I know that a lot was talked about. He talked about damages and all that. But his ultimate conclusion can be found on the last line of that, which says she doesn't have a cause of action for negligence because she very clearly settled it away. He very clearly settled it away.
There's one other part to the questions that I think Judge Lucas and Judge Atkinson are asking, and something that I said earlier is there could be arguably a contractual waiver of the right to defend on this kind of issue. Maybe yes, maybe no, cases don't address it. But you don't have a signature by or on behalf of your client on the release. It's a release by the plaintiff. Mm-hmm. So to the extent that there was some other agreement that would constitute an agreement not to defend under this body of law, it doesn't appear that that's been presented to the trial court or to us.
Yes, you are correct. So what we have in the record is just a release signed by the plaintiff. It is not signed by my client, and I know that plaintiff's counsel, trial counsel, filed some documents of correspondence back and forth between her and a claims adjuster with my client's carrier at this time pre-suit. But as far as this release, this does not have my client's signature, nor that might be a case for another day, but that was not the case before the trial court here, what that trial judge was asked to decide in this case. They have not asked for that. The trial judge was not presented with that, nor was he asked to make that decision. So he didn't. He made the correct decision under Florida law with what the case was presented, and that's, can I have a case solely for punitive damages? And the Florida Supreme Court said no. And ultimately, Your Honors, if if the plaintiff did make a mistake of law in that regard, my client shouldn't be punished for that, nor should a trial judge be reversed for following the law and doing the right thing under Florida Supreme Court precedent. And unless your honors have any other questions, I'll rely on my briefs and yield the rest of my time.
Very good. Thank you, Ms. Meckel.
As to the contractual waiver issue, even though we haven't presented it, if this release, which excludes punitive damages, would have been provided by and accepted by the other side, then they are agreeing to the fact that punitive damages are not included in the settlement.
Well, they'd be agreeing that the release tries to preserve a right to them, but it would not necessarily establish that they have waived their right to defend based on an existing body of case law.
It doesn't establish it, but it also doesn't work in their favor saying we never waived it. That issue, since it's been brought up here for the first time, has not been decided, but what I'm saying, it's not...
Well, it was not argued either in the trial court.
No.
So it's not something we would be able to address for the first time on appeal.
But Judge Lucas seemed to be interested in whether, that was, I'm sorry, it was Judge Atkinson, whether it was waived by the release or not.
We're always interested in all sorts of things.
I
Doesn't mean
know,
we can get to them.
And listening to the other oral arguments today, I had an oral argument on Monday, and one of them was, I think one of the parties brought up a question of about the written order comporting to oral pronouncements. And my case on Monday was whether the oral pronounces of the magistrate have to comport to her written report and recommendation. So we'll see what the third DCA says on that one.
It's what keeps us all in business.
Yes. But as far as this goes, I would also, in closing, just say that this is almost a case of first impression. We have no disagreement with the fact that Mr. McElreath could not have filed a claim saying, and the only thing he was seeking was punitive damages. What he thought he was doing was the fact that since he had the only way to get the punitive damages that he was entitled to, or would most likely be entitled to, let me put it that way, was to bring a claim seeking to have a determination of liability, something that Ms. Gonzalez also reserved and said she was not agreeing to. So therefore, each party reserved something in that settlement. Ms. Gonzalez reserved the fact that she was liable. She was not admitting liability. And Mr. McElreath reserved the right to pursue punitive damages claims. The problem is that the only way to do that is to bring a claim to determine liability, and that's why we are before this court. We're saying that he does not need compensatory damages. He just needs to have a vehicle to prove liability, to amend, to add his punitive damages claims. And we leave it in your capable hands, Your Honor, and thank you for your time.
Thank you, counsel.